Good evening to all of you. Let me know if I'm audible and visible to you people. Please just let me know that so that we can continue with our discussion. Yes? Am I audible and visible to you people? Please just quickly confirm it so that we can continue with our discussion for today's session. हाँ जी. Am I audible and visible? Okay, so I assume that I am audible and visible to all of you. Now let's start today's discussion. So today basically we are going to discuss section 33 to section 60 of majorly section 33 to section 60 of Indian Evidence Act, right? So shall we start the discussion? Anyone wants any kind of doubt he is having or she is having in the previous session? किसी को कोई डाउट है previous sessions में? Yes. हाँ जी. चलिए, so I assume that none of you are having any kind of doubt or confusion in your mind. So let's start today's discussion. The first question is section 45 of Indian Evidence Act. The opinion of the expert can be for option A, identity of handwriting, option B, identity of finger impression, and option C, both A and B, and option D, neither A nor B. What should be the correct answer? Question is very much simple and straight in front of us. That under section 45 of Indian Evidence Act, the opinion of the expert can be for identity of handwriting, identity of finger impression, both A and B, neither A nor B. What should be the correct answer? जल्दी से बताइए. हाँ जी. Opinion of the expert is important or opinion of the expert matters in the cases of identity of handwriting, identity of finger impression, both A and B, and none of the above. So its correct answer will be option C. Now, if you will read section 45 of Indian Evidence Act, it simply states that the opinion of the expert can be given on handwriting, finger impression, on any science question, art question. ठीक है? So for all of these things, the opinion of the expert can be given. So here the question is कि section 45 में opinion of the expert is relevant or can be taken, ठीक है, to identify the handwriting, to identify the finger impression, both A and B, and none of the above. So its correct answer will be both A and B. So C is the correct answer. Now moving towards next question. Next question क्या बोल रहा है? Under section 45 of Indian Evidence Act, the opinion of the expert can be on the question of. Opinion of the expert can be on the question of. Your options are Indian law, foreign law, both A and B, and only A, not B. What should be the correct answer? The opinion of the expert can be taken on which of the following question? Your options are Indian law, foreign law, both A and B, and none of the above. What should be the correct answer? क्या होगा इसका correct answer? जल्दी से बताइए. What will be the correct answer? So, if you remember, if again we will read section 45. So section 45 states that the opinion of the expert can be taken on any question of foreign law. but not any question of Indian law. So foreign law के लिए we can take the opinion of the expert. So its correct answer will be your option B for Bangalore. किसी को कोई confusion है? Yes. बहुत easy and straight question था ये. Moving towards next question. Next question किसके बारे में बात कर रहा है? Opinion of the expert under section 45 of Indian Evidence Act is a conclusive proof, is not a conclusive proof, is supportive and corroborative in nature, both A and C. What should be the correct answer? Opinion of the expert is a conclusive proof, not a conclusive proof, is supportive and corroborative in nature, and both A and C. What should be the correct answer? हाँ जी, जो ओपिनियन ऑफ द एक्सपर्ट होता है क्या वो कंक्लूसिव प्रूफ है या फिर वो कंक्लूसिव प्रूफ नहीं है या फिर इट इज सपोर्टेड एंड कोरोबोरेटिव इन नेचर, एंड ऑप्शन डी आइदर ए और सी. So its correct answer will be your option C, that opinion of the expert is not a conclusive proof in any of the case. That cannot be the sole basis of conviction, but if it is supportive and corroborated with other evidence, ठीक है, जैसे कि फॉर एग्जांपल वो बोलना क्या चाह रहे हैं कि एक हैंडराइटिंग एक्सपर्ट ने, ठीक है, इन द ओपिनियन ऑफ एक्सपर्ट, ये जो हैंडराइटिंग है एक पर्टिकुलर काइंड ऑफ हैंडराइटिंग है, दैट इज द हैंडराइटिंग ऑफ ए, राइट. अब व्हाट हैपेंस अहेड? The same proof have been found, like Mr. B come and says कि he has seen Mr. A writing that letter in which handwriting was examined. So basically that opinion of the expert has been corroborated by some other evidence, so that can be the basis of conviction. So its correct answer will be option C, right? Next, a disputed handwriting can be proved. एक डिस्प्यूटेड हैंडराइटिंग को कैसे प्रूव किया जा सकता है? ऑप्शन ए बाय कॉलिंग एन एक्सपर्ट, ऑप्शन बी बाय एग्जामिनिंग अ पर्सन एक्वेंटेड विद द हैंडराइटिंग ऑफ द राइटर of the question document, option C by comparison of two admitted and disputed handwriting, option D all of the above. What should be the correct answer? इसका करेक्ट आंसर क्या होगा जल्दी से बताइए. क्वेश्चन नंबर 4, what should be the correct answer? A disputed handwriting can be proved by calling a handwriting expert, moving ahead by examining the person acquainted with the handwriting of so questioned, or by comparison of two handwritings, one of which is admitted and proved. What should be the correct answer? क्या होना चाहिए इसका करेक्ट आंसर बताइए. क्वेश्चन नंबर 4 का. So its correct answer will be option D, because all of these are ways to examine the handwriting of a person. Section 45 के अंदर opinion of the expert can be taken on handwriting. Section 47 के अंदर the court can call the person who is acquainted with the handwriting, and by the comparison of two handwriting, one is in dispute and another one is proved. ठीक है, this thing can be taken care of by the court. ठीक है, specifically stating under section 73. ठीक है, so its correct answer will be D, that is all of the above. Next question, question number 5. The inter alia acta is receivable under, inter alia acta is receivable under section 45 of Indian Evidence Act, section 46 of Indian Evidence Act, section 47 of Indian Evidence Act, and option D section 48 of Indian Evidence Act. Inter alia acta is admissible, ठीक है, under which of the following section of Indian Evidence Act? Section 45, section 46, section 47, section 48. What should be the correct answer? अब देखिए पहले तो इंटर एलिया एक्टा का मतलब समझ लेते हैं व्हाइल यू आर आंसरिंग दिस क्वेश्चन. रेस इंटर एलिया एक्टा मीन्स द एक्ट्स or you can say facts not otherwise relevant become relevant. तो ये चीज एक तो आपको सेक्शन 11 में देखने को मिलेगी, दैट इज टॉकिंग अबाउट रेस गेस्टे फॉर्मिंग सॉरी दैट इज टॉकिंग अबाउट plea of alibi meaning being elsewhere. So facts which are not otherwise relevant become relevant if they are directly questioning or supporting the statement of the accused or victim. ठीक है, वॉट एवर एविडेंस दे आर प्रोड्यूसिंग. लेकिन ओपिनियन ऑफ द एक्सपर्ट के केस में ये कब हो सकता है? सो दैट इज अंडर सेक्शन 46, बिकॉज सेक्शन 46 यही चीज बोल रहा है कि इफ द ओपिनियन ऑफ द एक्सपर्ट comes on a particular fact, then even if that fact was not relevant, become relevant under section 46 if it is supporting or corroborating or going against or contrary to the opinion of the expert. Entries in the books of accounts regularly kept in the course of business are admissible under section 34 of Indian Evidence Act. Option A, if they by themselves create a liability. Option B, if they by themselves do not create a liability. Option C, irrespective of whether they themselves create a liability or not. Option D, either A or B. What should be the correct answer? क्या होगा इसका करेक्ट आंसर क्वेश्चन नंबर 6 का? बताइए जल्दी से, व्हाट शुड बी द करेक्ट आंसर ऑफ क्वेश्चन नंबर 6? हाँ जी. So its correct answer will be option C, irrespective of whether they themselves create a liability or not. Such kind of facts will become important or relevant. ठीक है. Question number 7. When the court has to ascertain the relationship between one person and another, the opinion of any person having special means of knowledge and expressed by the conduct is admissible under. When the court has to create the relationship of one person with another, irrespective of the fact, ठीक है, irrespective of any other fact, ठीक है, the opinion of any person having means of special knowledge expressed by the conduct is admissible under section 51, section 50, section 52, section 49 of Indian Evidence Act. What shall be the correct answer? Question number 7. क्या होगा इसका करेक्ट आंसर? जल्दी से बताइए. हाँ जी. In simple way, they are asking opinion relating to the relationship when relevant. This is the heading of section 50. So its correct answer will be option B. Right? चलिए आगे बढ़ते हैं. Moving towards next question. The relationship in section 50 of Indian Evidence means relationship by blood, relationship by blood or marriage, relationship by blood, marriage or adoption, only A and not B and C. Question number 8. What should be the correct answer? The relationship in section 50 of Indian Evidence Act means the relationship by blood, the relationship created by blood or marriage, the relationship created by blood, marriage or adoption, only A and not B and C. What should be the correct answer? Its correct answer will be your option C. That means a relationship created by blood or marriage or adoption. Right? Moving towards next question, question number 9. The opinion as to relationship of marriage under section 50 of CPC, under section 50 of, by mistake लिखा हुआ है ये CPC, under section 50 of Indian Evidence Act, is admissible in the cases of offenses against marriage, is admissible under Indian Divorce Act, is admissible under both A and B, and option D, none of the above. What should be the correct answer? Opinion as to relationship of marriage under section 50. ठीक है. is admissible under Indian Marriage Act, under Indian Divorce Act, both A and B, and none of the above. That means it is neither admissible in the case of marriage nor admissible in the case of death. What should be the correct answer? So its correct answer will be your option D. That means if any particular relationship has been created, okay, that is not admissible against marriage or in any proceeding under Indian Divorce Act. Now 10th क्वेश्चन थोड़ा सा लेंदी है, प्रोपोजिशंस के बारे में बात कर रहा है. प्रोपोजिशंस अंडर इंडियन एविडेंस एक्ट आर in civil cases character evidence is inadmissible unless the character of a party is a fact and issue. In criminal cases the evidence of a good character is admissible generally. Option like statement number proposition number 3, in criminal proceeding evidence of bad character is inadmissible unless the same is a fact and issue. Option like proposition number 4, in criminal proceeding evidence of bad character is admissible only when good character has been given. What shall be the correct answer? Question number 10. क्या होगा इसका correct answer? All 4 propositions are correct. First, second, third are correct. First and second are correct. First and third are correct. First, second, fourth are correct. Second, third, fourth are correct. What should be the correct answer? आराम से पढ़िए, थोड़ा टाइम लेके पढ़िए, कोई जल्दी नहीं है इस क्वेश्चन के साथ. क्वेश्चन को पढ़िए और समझिए. If you have studied section 52 to 55 of Indian Evidence Act, you will be able to answer this question easily. आराम से आंसर बनेगा इसका. बताइए what should be the correct answer? हाँ जी, क्या होगा इसका सही आंसर? सिविल केसेस में कैरेक्टर इज इनएडमिसिबल, क्रिमिनल केसेस में कैरेक्टर ऑफ गुड कैरेक्टर is admissible. In criminal cases bad character is admissible if it is fact and issue. In criminal cases bad character is admissible if it is to prove the good character which has been given by the that defense counsel. What shall be the correct answer? So its correct answer will be option A. That is all 4 statements are correct. चारों statement सही है, चारों proposition सही है. Next question. Question number 11. Facts of which judicial notice is to be taken are stated under section 56, 57, 58, 55. Facts of which judicial notice has to be taken is discussed under which of the following section? 56, 57, 58, 55. क्वेश्चन नंबर 11, सोच के आराम से आंसर कीजिए. What should be the correct answer? Index based question है. Facts of which judicial notice is to be taken are stated in section 57. So its correct answer will be B for Bangalore. Now, list of facts of which judicial notice has to be taken under section 57 of Indian Evidence Act is exhaustive, is illustrative only, is both A and B, is neither A nor B. Question number 12. What should be the correct answer? List of facts of which the court can take the judicial notice under section 57 of Indian Evidence Act is exhaustive, illustrative, both A and B, and neither A nor B. What should be the correct answer? Question number 12. So its correct answer is option B. It is illustrative only. Next question. Facts which need not to be proved by the parties includes the facts of which judicial notice has to be taken. Option A. Option B, facts which have been admitted by the parties at or before the hearing, both A and B, and neither A nor B. अगर आपने सेक्शन 56 to 58 चैप्टर 3 को पढ़ा है तो ये क्वेश्चन आपसे बन जाएंगे। क्वेश्चन नंबर 11, 12, 13 ये सभी उस पे ही बेस्ड है। क्वेश्चन नंबर 13, व्हाट शुड बी द करेक्ट आंसर, बताइए। Facts of which need not to be proved by the parties includes facts of which judicial notice has to be taken, facts of facts which have been admitted by the parties at or before the hearing, both A and B, neither A nor B. So its correct answer will be ऑप्शन सी, बोथ ए एंड बी। अब देखिए ये आपको, इफ यू विल रीड सेक्शन 57, इट सिंपली स्टेट्स that if a particular fact का judicial notice has to be taken, that facts need not to be proved, and if a particular fact has been admitted by the party at or before the hearing under section 58, then such fact need not to be proved। अगर सामने वाली पार्टी ने, अपोजिट पार्टी ने जिसके अगेंस्ट आपको प्रूव करना है, that party has admitted, then the fact need not to be proved until and unless it is specifically stated by the court। Next, the question number 14, the court may in its discretion call for proving of fact of which judicial notice has to be taken, facts which have been admitted otherwise than such admissions, option C both A and B, option D neither A nor B। What should be the correct answer? The court may in its discretion call for proving of the facts of which judicial notice has to be taken, which have been admitted otherwise than on such admission, option C both A and B, option D neither A nor B। What should be the correct answer? Its correct answer will be option B। देखो, the court has to take judicial notice of certain facts, then such facts need not to be proved in any of the circumstances, but if a particular fact has been admitted by one party, ठीक है, and the next party like doesn't want to prove it, then also the court may insist the next party to prove that particular fact। Question number 15, oral evidence under section 60 of Indian Evidence Act may be, oral evidence may be direct only, hearsay, both A and B, either A or B। Question number 15, what should be the correct answer? Oral evidence under section 60 of Indian Evidence Act may be direct only, hearsay, both A and B, either A or B। क्या होगा करेक्ट आंसर 15 का, जल्दी से बताइए। Oral evidence under section 60 has to be direct only, hearsay, both A and B, either A or B। So its correct answer will be your option A, because as per section 60 the oral evidence has to be direct, but there are some exception in which hearsay evidence can be admitted, and these exceptions are section 24, section 6, section 32 subclause 1 that is dying declaration, confession, res gestae, ठीक है, या फिर आपका सेक्शन 60 में ही एक एक्सेप्शन दिया है, द बुक्स ऑफ ट्रिटाइज, लाइक ट्रिटाइज ऑफ अ बुक, मतलब किसी भी बुक के ऑथर का कोई ओपिनियन है, ठीक है, एंड देन इन दैट केसेस द hearsay evidence can be admitted। So its correct answer will be your option A। Contents of a document under section 59 of Indian Evidence Act can be proved by, contents of a document under section 59 of Indian Evidence Act can be proved by, option A can be proved by oral evidence, option B cannot be proved, by oral evidence. Option C, may or may not be proved by oral evidence. Option D, can be proved only by oral evidence under the order of the court. Question number 16. What should be the correct answer? Contents of a document under Section 59 of Indian Evidence Act can be proved by oral evidence, cannot be proved by oral evidence, may or may not be proved by oral evidence, can be proved by oral evidence under the order of the court. What should be the correct answer? क्या होगा इसका सही जवाब? हाँ जी. Now, its correct answer will be cannot be proved by oral evidence, because it is very much clearly stated under Section 59 that the contents of a document can be proved by only by any other document. So oral evidence cannot be given on such subject matter. Now, moving ahead, question number 17. Contents of a document may be proved under Section 61 of Indian Evidence Act by primary evidence, by secondary evidence, either by primary or secondary evidence. Option D, only by primary evidence and not by secondary evidence. क्या होगा इसका correct answer? Contents of a document can be proved under Section 61 of Indian Evidence Act by primary evidence, by secondary evidence, either by primary or secondary evidence, only by primary and not by secondary evidence. अब देखिए यहाँ पे आपको समझना क्या है कि प्राइमरी एविडेंस कौन से होते हैं और सेकेंडरी एविडेंस कौन से होते हैं. दैट इज वेरी मच इंपॉर्टेंट टू अंडरस्टैंड. ठीक है. प्राइमरी एविडेंस मतलब डायरेक्ट ओरिजिनल कॉपी ऑफ द डॉक्यूमेंट हैज बीन प्रेजेंटेड टू द कोर्ट. जैसे कोई विल है, डीड है, उसका ओरिजिनल कॉपी आपने लाके रख दिया. And secondary evidence as defined under section 63 includes various kind of evidence. ठीक है. various kind of evidence मतलब xerox of a document, ठीक है, certified copy of a document, counterpart of a document which has been signed by one party. ठीक है. signed by the party by his own. तो ये सारे हो गए आपके secondary evidence. तो the contents of the document can be proved by any of these ways. ठीक है. Next question. Question number 18. Secondary evidence of a document means copies of that document, oral account of contents of the document. Option C, both A and B. Option D, only A, not B. Question number 18. What should be the correct answer? Secondary evidence of a document means copies of that document, oral account as to the contents of document, both A and B, only A, not B. क्या होगा इसका करेक्ट आंसर? जल्दी से बताइए. हाँ जी. तो it includes copy of document as well as oral account of contents of the documents only if permitted by the court. So its correct answer will be option C, both A and B. Next question. Question number 19. Secondary evidence of a document is admissible as a substitute for admissible primary document, inadmissible primary evidence under certain circumstances, inadmissible primary evidence under all circumstances. Option D, both A and B are correct. Secondary evidence of a document is admissible as a substitute for admissible primary evidence, inadmissible primary evidence under certain circumstances, inadmissible primary circumstances under all circumstances, and option D, both A and B are correct. तो अगर किसी पर्टिकुलर डॉक्यूमेंट का प्राइमरी एविडेंस ही एडमिसेबल नहीं है, उसकी ओरिजिनल कॉपी ही एडमिसेबल नहीं है, तो क्या उसका ज़ेरॉक्स एडमिसेबल होगा कोर्ट में? यस और नो? नहीं होगा ऑब्वियसली. सो एडमिसेबल प्राइमरी एविडेंस, ए इज द करेक्ट आंसर फॉर दिस. नेक्स्ट क्वेश्चन, क्वेश्चन नंबर 20. Now, the circumstances under which secondary evidence is admissible has been enumerated under section 63, 64, 65, 66. कितना सीधा सिंपल बना दिया. इंडेक्स बेस्ड क्वेश्चन है. The circumstances under which secondary evidence is admissible have been enumerated in section 63, 64, 65, 66. What should be the correct answer? अब देखिए, अगर आपने इंडेक्स पढ़ा है तो आपको ये क्वेश्चन डायरेक्ट आ जाएगा. इंडेक्स बेस्ड क्वेश्चन है. सेक्शन 63, 64, 65, 66. व्हाट शुड बी द करेक्ट आंसर? बताइए जल्दी से. Its correct answer will be option C, that is section 66. Sorry, 65. Right? Secondary evidence is admissible. Option A, where non-production of primary evidence has not been accounted for. Option B, where non-production of primary evidence has been accounted for. Option C, irrespective of whether the non-production of primary evidence has been accounted for or not. Option D, both A and C are correct. क्या होगा? सेकेंडरी एविडेंस की एडमिसिबिलिटी कब आएगी? सेकेंडरी का मतलब क्या है? बाद में आने वाला. और प्राइमरी मतलब पहले आने वाला. सो ऑब्वियसली द फर्स्ट प्रायोरिटी विल बी गिवन टू द प्राइमरी एविडेंस. अगर ओरिजिनल नहीं है, प्राइमरी नहीं है, तब फिर सेकेंडरी कॉपी पे बात आएगी. तो obviously where the non-production of primary evidence has been accounted for, then only secondary evidence is admissible. So its correct answer will be option B. Now, question number 22. Oral account for the content of document is admissible when given by a person who has seen and read the document. When given by a person who has seen but not read the document. Option C, when given by a person to whom the document was read over. Option D, when given by any of the above. क्या होगा इसका करेक्ट आंसर? Oral account as to the contents of document are admissible only when it is given by a person who has seen and read the document. Only the person who has seen the document and not read the document. When given by a person to whom the document was read over. Option D, when given by any of the above, means all of the above. Question number 22, its correct answer will be A, when given by a person who has seen and read the document. जब भी किसी इंसान ने वो डॉक्यूमेंट देखा है और पढ़ा है, then only the contents of the document can be proved by that person on his account through oral evidence. Next question. A document required by law to be attested can be proved under section 68 of Indian Evidence Act only by calling both of the attesting witness, by calling any one of the attesting witness, by calling none of the attesting witness, but by calling some other person who has knowledge of the content. D, all of the above is correct. अब देखिए, ये क्वेश्चन ना सेक्शन 68 से कनेक्टेड है. ठीक है? तो a document required by law to be attested can be proved under section 68 of Indian Evidence Act only by calling both of the attesting witness, only by calling at least one of the attesting witness, only by calling none of the attesting witness, but by calling some other person who has knowledge of the contents. D, all of the above are correct. So its correct answer will be option B. ये question बहुत पूछा जाता है. ठीक है? So in the cases of contents of the document, ठीक है, attested document, the statement or the contents of a document can be proved by calling any one of the attesting witness. The calling of at least one attesting witness to prove a certain document under section 68 is not necessary. when the document other than the will is registered under Indian Registration Act, when the document including will is registered under Registration Act, when the document irrespective of whether it is a will is registered under Indian Registration Act 1908. Option D, both B and C are correct. क्या होगा? When a particular document is registered under Indian Registration Act, then what will happen? Section 68 में ही इसका आंसर है that when a document other than a will is registered under Indian Registration Act, such document doesn't require any kind of proof from the attesting witness. So its correct answer will be option A. Now, last question for the day. A will is required to be proved by calling at least one of the attesting witness when it is registered, when it is unregistered, when it is admitted, and D, all of the above. A particular document required to be proved by calling attesting witness when it is registered, when it is unregistered, when it is admitted, and D, all of the above. What should be the correct answer? हाँ जी, its correct answer will be your option D, that is all of the above. ठीक है, so whether a particular document is registered or unregistered, in all the cases such document has to be proved, ठीक है, by calling the attesting witness. I hope it's clear to all of you and you people have enjoyed today's session. Now see you people in the next session with some new discussions. ठीक है, tomorrow we are going to discuss from section 61 to 90. ठीक है, even like we have covered some of the provisions of section 67 68 तक today. ठीक है, चलिए मिलते हैं नई क्लास में कुछ और नए डिस्कशंस के साथ and we'll have more fun together. Till the time, stay healthy, stay happy and stay safe all of you.